We are starting now. Today is 233 for Friday group meeting. Speaker is our beloved Sridhar Potaraju, senior advocate. After senior designation, is first time he is addressing our Friday group. Earlier, 2-3 occasions he addressed. That is on 2nd February 2018. That is 71st Friday group meeting. The Uttarakhand High Court judgment, juristic person, etc. And 153 Friday group meeting also, that is dated 26/8/2022. Indian Maxims, one of the best. He himself wrote that book, and Rama Subramanian has given a footnote and etc. Preface, sir. 195 Friday group meeting also he addressed, that is 10th November 2023. Rejection of plaint, sir. Sridhar, your contribution for Friday group YouTube channel is 7,000 almost. Today's topic is Constitution Bench judgment, recent one, that is dated 17/10/2024. Section 6A of the Citizenship Act 1955, pursuant to the Assam Accord dated 15/8/1985. The judgment is reported and it's not in SCC or anything. Sridhar, now you can initiate. Yes. Please, 1 second.
Good afternoon, friends. Thank you very much, Seshu sir, for giving me this opportunity again. So the topic for the day is very interesting subject. The recent judgment of the Supreme Court, which has actually considered the challenge to the Section 6A of the Citizenship Act 1955. The challenge has arisen in the context of the problem of migration into Assam from Bangladesh. So I was going through this judgment and then I realized that this is a very unique case which actually brings forth certain issues which probably people of my generation were not familiar with, namely the fallout of partition and then the umbilical cord of partition still actually holding good for certain people, though they may now be part of a different sovereign nation. So it is in this context that this issue has arisen, especially in the state of Assam. There was a serious challenge as far as the issue of migration from Bangladesh is concerned. Now I spoke to Seshu sir and then I realized that this judgment cannot be covered without giving a very detailed factual backdrop about the problem per se, because I was myself not very privy to the factual complexities involved, which has led to the amendment of Section 6A in 1985, which in turn was preceded by a Assam Accord, what is popularly known as the Assam Accord in 1985, led by a student agitation of P.K. Mohanta, who later I think became a Chief Minister also. So it is in this context that today I would like to address the factual backdrop or the historical backdrop of Assam. Now, as we all know, the Northeast has 7 states, the 7 sisters, but broadly, politically, they were all part of the state of Assam and they were within the same administrative regime. So now if we look at the historical aspects of this development of this part of the country, Justice Parthiwala is in dissent in this judgment, but I have culled out the broad dates and events from his dissenting opinion because he has taken great pains to set out the historical backdrop. The Constitution Bench judgments sometimes, apart from actually contributing to the jurisprudence of our country, are also documents which actually record the history in a debated contest, because certain assertions and denials happen in a court of law in the course of a debate over a legal issue. So it is in this backdrop that the history of this entire discord amongst the people who are native Assamese as against people who are migrating, for the Bengali speaking people migrating from Bangladesh. So it is in this background that I would like to just place the factual backdrop in today's talk and then introduce the broad contours of the challenge. And then Seshu sir has been kind enough to permit me to address the legal issues and the constitutional issues as formulated and addressed in 3 distinct opinions. Now, to summarize, the judgment has upheld the validity of Section 6A, which was introduced by the 1985 amendment to the Citizenship Act 1955. Justice Suryakant has given the lead judgment. Chief Justice Chandrachud has concurred with him, and Justice Pardiwala has given a dissenting view, and he's given out very succinct reasons which are very, very persuasive as to the reasons and the conclusions that he arrives at to hold that Section 6A is unconstitutional. In the process, he's also brought in a concept of temporal unreasonableness, adding it to the existing realm of constitutional validity being challenged on the ground of manifest arbitrariness. So to just give a perspective, before I go into the factual narration, the temporal unreasonableness is something which has come out of this judgment, where we are all familiar with the challenge under Article 14 to any legislation being unreasonable, irrational, and manifestly arbitrary, which is now a part of our settled jurisprudence. Now, manifest arbitrariness has the trappings of determining the validity or invalidity with reference to the constitutional ethos and values at the time of the consideration of the enactment when it was challenged. But Justice Pardiwala has now extended and expounded the proposition or a doctrine of temporal unreasonableness, where he says, this is not something new. It has been considered earlier as well. But he's actually expounded it and brought it out in a very beautiful manner. And he explains that something which could be probably constitutionally valid at a point of time in this political and social strife-driven circumstances in which the nation was, or the particular state was at a point of time in 1985, when this Assam Accord was made and the amendment to the Citizenship Act had to be made. But with the experience of the working of the statute and also the failure to implement the intent of the Assam Accord, which was the primary object of interpreting or introducing the amendment and inserting Section 6A. It is in this context he examines the manifest arbitrariness with a temporal unreasonableness, that is with passage of time, the test of unreasonableness will have to be applied, and to see if that particular amendment which is under challenge still holds good, or it needs to be determined to be actually unconstitutional. It is in the factual backdrop of the case on hand that he explains this proposition and holds that the amendment has actually outlived its purpose and in fact has been counterproductive, is the view of Justice Pardiwala in his dissenting opinion. Whereas the majority opinion is of the view that this amendment, which is the Section 6A, not to be read in isolation. It has to be read as a part of the other statutory provisions which have to be given a harmonious interpretation to bring forth the purpose for which the amendment was brought in, and upholds it, holding that there is no manifest arbitrariness in insertion of Section 6A into the Citizenship Act as well as the implementation thereof. The Supreme Court has chosen now to give certain directions for a proper implementation of this amendment and has retained the supervisory control over this issue by deciding to monitor the implementation of the directions Justice Suryakant has spelled out in his lead judgment on behalf of the majority. So that is the overview of the judgment. Now if I go back to the history, the northeastern part of India, which is broadly referred to as Assam in the historical context, it was constantly invaded from Burma, and this area there were conflicts during the British period also between the British controlling the Indian terrain, the East India Company's jurisdiction, and subsequently the British Crown exercising its sovereign powers, and the Burmese. So there was a treaty of 24th February 1826. The treaty was signed between the British East India Company and the Burmese Kingdom, ceding territories of Assam to British. So therefore, this historical context gives a contiguity to that region and then overlapping ethnicity also. So probably this history is something which is very unique for all of us to understand certain complex issues that we keep hearing and reading about in the northeastern states, and certain issues which are still live in certain parts of the northeast as on date. The Assam province was established under the British, and then the inner line regulation was introduced in 1873. So this inner line regulation is a restriction as to the access to outsiders to certain areas which are core. So there is no free movement permitted in certain areas where these permits were required. Thereafter, the British administration has introduced in 1836 Bengali as an official language in the Assam region. Assamese was a primary language there, and Bengali was also brought in. Thereafter, the charter was granted to the East India Company to hold land outside the presidency towns on long-term lease or with freehold rights. This paved the path for a colonial plantation company named Assam Company, which was started in 1839. So therefore, the entry of corporates, the British corporates, into the Northeast happened, which has led to exploration of oil, tea plantations and economic exploitation of the northeastern region. Assam's status as a separate province came to an end and was reconstituted as part of a newly born composite province of Eastern Bengal and Assam in 1610-1905. In 1937, when the Government of India 1935 Act came into force, the territory of Burma ceded from India and Assam was incorporated as a territory of India under the 1935 Act. The issues then turned to the partition. The partition resulted in migration of population across the then East Pakistan, which is now Bangladesh, and of course West Pakistan, which is Pakistan. So India was in between, and there were two independent parts of Pakistan. The West Pakistan now was liberated subsequently. In 1950, there was a Nehru-Liaquat agreement aimed at safeguarding the minority communities in each country amidst growing tensions and migration concerns. Now with this background, we come to the Immigration Expulsion from Assam Act 1950. It was enacted to address the influx of immigrants from Pakistan into Assam. So Assam has been facing the challenge of influx from what the present day Bangladesh is concerned as early as probably 1947 onwards, that there was a statute, Immigrants Expulsion from Assam Act 1950, which is still in operation. In 1955, the Indian Citizenship Act was established with provisions for acquiring citizenship in India and allowing registration of migrants from Pakistan. Now we all are familiar that the Constitution per se recognizes citizenship at the inception, but the 1955 Act actually regulates grant of citizenship subsequent to the Constitution coming into force. Apart from descent and natural born children here, there are various categories under which citizenship can be acquired subsequently. Now, the critical stage for this judgment or section 6A of the Citizenship Act, I am marking these days 1st January 1966 and prior thereto. So the first cutoff, as it is referred to in the Constitution bench, is for the period pre-1st January 1966. The reason being that the section 6A, which was introduced in 1985, recognizes anyone who has entered and started living in Assam, though may not be a citizen under the Constitution, but would be deemed to be an Indian citizen, provided they have come in prior to 1/1/1966. Now then there is a second window which is called a second cutoff under the impugned section 6A. The second period is 1st January 1966. So the period prior to 1st January 1966 is the first cutoff. I am using the reference of the language used in the judgment for convenience. and the dates are emanating from the judgment itself. The second cutoff is referable to section 6A3 small a. Here what happens is that here is a period, all of us are familiar with the liberation of Bangladesh in 1971. So we are treating the period 1966, January 1st to 25th March 1971. Anyone who's entered the territory of Assam during this period, and if they had managed to even get into the electoral rolls, were required to be identified and declared as an immigrant, and then they were conferred certain benefits of citizenship except the voting rights. So that is the effect. I'll elaborate that when I reach the amendment itself. On 25/3/71, the Operation Searchlight was commenced by the Pakistani army on East Pakistan, and then we refer to as the Bangladesh Liberation War. The Pakistani army's project led to a lot of genocide of innocent civilians. So that led to a humanitarian crisis, with millions of people trying to save their kith and kin, and then walked into the Indian territories of Assam and Bengal. So that numbers were humongous. So on one place the judgment records about 57 lakh people had moved into Bengal, and approximately 41 lakh people had moved into Assam. Though Bengal received more immigrants, but having regard to the terrain and the geographical size of the state of Assam, it was considered that it was definitely altering the rights of the native Assamese people because of the influx of such a large number of people from outside. So in 1972, there was a agreement between the Prime Minister of India, Srimati Indira Gandhi, and Sheikh Mujibur Rahman, Treaty of Friendship, Cooperation and Peace known as the Indira Mujib Agreement. Thereafter, on 15 December 1972, Bangladesh Citizenship Temporary Provision Order 72. The order granted citizenship in Bangladesh with retrospective effect from 26 March 71, aimed to addressing staleness. So there were a lot of people who had migrated here and there. So that was being addressed pursuant to that. In 1979, there was a foreigners tribunal which was established in Assam. There were 10 tribunals were constituted to manage the pre-25th March 71 foreigner cases. See, the Foreigners Act was in place. That act actually dealt with a particular procedure for identifying and deporting foreign nationals who have entered the Indian territory without valid legal documents. Thereafter, during the period 1979 to 1985 was a political turmoil. The people realized that a lot of illegal migrants have managed to get documents, and then they've entered the electoral rolls, and they were in a position to influence the outcome of a democratic election either to the assembly or the parliament. So this is the trigger for what continued for more than 6-7 years, the student agitation in Assam, where this issue actually became a flashpoint between the local Assamese people and the immigrants. Even now we see a lot of political rhetoric on either side on this issue in that state. In 1983 there was an unfortunate communal flare-up, and that actually exploded as it would be the last straw which broke the camel's back. The patience of the people had gone, and the entire students had come onto street protesting this overawed explosion of immigrant population which is taking over the resources of the state and also occupying their lands, which was forcing them to leave their own natural habitats and then their own cultural practices because of the change of demography. So then in 1983, the Illegal Migrants Determination Tribunal Act 1983 was enacted. It was enacted to provide a framework for identification of illegal migrants, specifically for Assam, and to expel or deport those found to be illegal migrants. Now, this Act was in force until subsequently in 2005, in Sarbanan Sonowal's case, the Supreme Court has quashed it. The agitation which had commenced in 79 was actually exploded in 83, and it led to the Assam Accord of 15 July 1985 between the Indian government and the leaders of the student agitation then, establishing a framework for addressing illegal immigration and leading to the inclusion of Section 6A in the Citizenship Act 1955. On 7/12/1985, the Citizenship Amendment Act 65 of 85 was enacted to include Section 6A, which is the subject of challenge before the Constitution bench, the validity of the said act, the said provision of Section 6A. The amendment was a result of the Assam Accord signed between the Government of India and the leaders of Assam, aimed at addressing the issue of illegal immigration in Assam by providing specific provisions for citizenship to migrants from Bangladesh based on their date of entry into Assam. Now, if we look at it, there is a conflict of vision insofar as the state policy to grant citizenship and the local populace, what you call as the disenchantment or probably angst at the overwhelming immigrants entering the state of Assam. Now, so there were two rival issues which were at the core of this Assam Accord. So the Government of India as a policy was acknowledging that people of Indian origin who were part of the undivided India pre-partition would or may want to come for various reasons. So now how do we accommodate them? So that Section 6A has introduced the two cutoffs for recognizing the people who actually belonged or were of Indian origin. Now, how does the Act recognize a person of Indian origin? The Act recognizes a person of Indian origin. Either he is a person of Indian origin himself, or any of his parent was a person of Indian origin prior to the partition, or any of the grandparents was a person of Indian origin prior to the partition and lived in the current sovereign state of Bangladesh. So at that point of time it was all India. So therefore anyone who was living in the current state of Bangladesh, the territory of Bangladesh prior to the independence, or their heirs, they were the people who were considered eligible provided they had entered and started residing in Assam prior to 1st January 1966. So this is referred to as the first cutoff. So Section 6A has recognized by statute them to be deemed to be citizens of India under the Citizenship Act. So they did not have to apply for any citizenship. They were statutorily recognized as belonging to India by virtue of a deeming fiction introduced by Section 6A. Now, the second cutoff which was introduced is for the people who entered from 1/1/1966 till 25/1971. Now, what is the importance of 25/371? 1/1/66 is understandable because anyone who had come before that was more or less getting a citizenship by operation of the Section 6A2, the first cutoff date. But the second cutoff date significance is a recognition of movement of people from Bangladesh or East Pakistan as it was for the period 1966 January 1st till 25th March 1971 when Operation Searchlight was launched. So the parliamentarians in their wisdom recognized that anyone who chose to come into Assam at that point of time prior to the launch of Operation Searchlight were coming probably for reasons other than the threat to their life pursuant to the Operation Searchlight. So they were not political refugees. But people who had come earlier, they had their roots or probably they had their cultural milieu in this side of the border, and therefore they could have moved on this side looking for a better revenue in their ancestral lands. It is a recognition of India or the subcontinent as the ancestral land for the people of this region, which is reflected in 6A.2, which gives a cutoff of 1166 any day prior to 1166 for granting them a deemed status of citizenship. Now, for people who come on 1166 till 25371, they have been recognized to be a separate class, and even if they had managed to get their voting rights or the electoral, they managed to get their names in the electoral rolls or have actually got some privileges which a citizen would have got, the onus was cast on the state to identify them as immigrants, illegal immigrants, and then proceed against them through the tribunals constituted to determine that, and the date of the opinion of the tribunal would be the date from which they would be given all rights of a citizen minus the voting rights. This is the language of section 6A.3. So if I may spell it out again. So the people who entered Assam from 1166 till 25371 and had already managed to get a voting right also were allowed to continue with the privileges of Indian citizenship, including a right to apply for and getting an Indian passport minus the right to vote. So in other words, a person who managed to get a voting right prior to that, once he is identified by the concerned tribunal to be a foreign illegal immigrant, his voting rights were clipped for a period of 10 years from the date the opinion was formed. Thereafter, the rights were preserved for a period of 10 years, and thereafter the limb of a voting right is also conferred on them. So what it does is that the immediate reason or the trigger for the agitation was the overwhelming inclusion of a lot of immigrants into the local electoral rolls, changing the electoral composition. See, as we see, the demographic change or a large-scale migration would actually alter the electoral dynamics of a particular constituency. So that was the trigger for the agitation, and then the government's policy was to acknowledge people of Indian origin to come back to their ancestral land, and thereafter taking it to 25th March 71 for people who had come after 1st January 66, curtailing their voting rights, but nevertheless giving them all other rights, including an Indian passport, which would enable them to travel abroad as an Indian citizen. And at 10 years later, that voting rights were also being restored to them. Now I'll just spell out the key features of this section 6A. For the purpose of this section, Assam means territories included in the state of Assam before the 1985 amendment, detected to be a foreigner by a tribunal constituted under Foreigners Act 1946 and the order dated 1964. So therefore the applicability of the act was for the territories, people inhabiting in the territories of Assam, qua a person who is detected to be a foreigner by the tribunal constituted under the Foreigners Act 1946 and the order of 1964. They are people who come from a specified territory. So specified territory is also defined, means territory included in Bangladesh prior to 1985 amendment to this particular amendment in question. And deemed to be a person of Indian origin would refer to his parents or any of his grandparents was born in undivided India, including the person in question. So the date on which the tribunal constituted under the Foreigners Tribunal Order 1964 submits its opinion to the concerned authority, he is a foreigner, shall be the date for the purpose of determining the 10-year period of disenfranchising that person, removing his name from the electoral roll, and then after a lapse of 10 years, his name can be restored to the electoral rolls. There were several other provisions also. 682. the first cutoff is introduced. By deeming fiction confers citizenship on all persons of Indian origin, that is, he or either of his parents or any of his grandparents was born in undivided India, who came before 1166 to Assam from specified territories included in Bangladesh before commencement of Citizenship Act. 6A3 provides for the second cutoff. Subject to the provisions of the procedural applications provisions of subsection 6 and 7, all persons of Indian origin who came on or after 11-1966 but before 25-371 from the specified territory since the date of his entry into Assam been ordinarily resident in Assam, has been detected to be a foreigner, shall register himself as an applicant for citizenship under the rules made under section 18. Even if his name is shown in the electoral rolls, the same shall be deleted therefrom. 6A4. A person registered under subsection 3 shall have the same rights and obligations as a citizen, including the right to obtain a passport, but shall not be entitled to have his name included in any electoral roll before expiry of 10 years. Section 6A5. A person registered under subsection 3 shall be deemed to be a citizen for all purposes from the date of expiry of a period of 10 years from the date of being detected to be a foreigner. So a deeming fiction has been brought in. Qua people who have come before 11-1966, the Citizenship Act recognizes or deems them to be citizen with all consequential privileges of a citizenship, including voting rights. But qua those who have come on 1166 until 25-371, the deeming fiction says that you will have all rights of citizenship, including a right to passport, minus the voting rights. And on the lapse of 10 years, the operative date for the determination of the 10-year period is the opinion of the tribunal that he is an immigrant after an inquiry, which is a quasi-judicial proceeding. So that actually sets out the entire parameters of the provision of 6A. I would like to place certain other provisions also, which are also referred to in the judgment of the Constitution Bench. The Indian Parliament has passed the Citizenship Amendment Act 2003, and which was notified on 7 January 2004. Amended section 21B to define the term illegal migrant. An illegal migrant was defined to mean a foreigner who entered India without a valid passport or other travel documents prescribed by law, or with a valid passport and travel documents but has overstayed. They also amended section 5. Citizenship by registration was amended to bar an illegal immigrant from applying under this section. Section 6 is citizenship by naturalization was also barred for an illegal immigrant. As a sequitur, all migrants entering Assam post 25-371 are barred from applying citizenship. So now what happens is that the people who had come prior to 25-371 by operation of the statute are conferred citizenship forthwith if they had entered prior to 1166. But if they had entered from 1166 till 25-371, they are conferred citizenship minus the voting rights for a period of 10 years from the date of determination as an illegal immigrant. Now, on 12/7/2005, the Honorable Supreme Court struck down the illegal migrants determinations by Tribunal Act, declaring it as unconstitutional. Justice Ranjan Gogoi and Justice Nariman's judgment. The court held that act was ineffective in addressing the large-scale illegal immigration into Assam and violated Article 355 of the Constitution, which mandates the Union government to protect the states from external aggression. This judgment stated that the influx of illegal immigrants constituted such aggression. 17 December 2014, the Assam Samhita Mahasangha versus Union of India, the reference to the Constitution was made. The constitutional validity of Section 60 of the Citizenship Act was challenged. The petitioners raised concern over influx of illegal migrants into Assam and sought a review of the special provision made for citizenship under Section 6A only for the state of Assam, which is a border state, by discriminating one border state qua the other border states. So that was the crux of the challenge of discrimination. A two-judge bench of the Supreme Court referred 13 issues of the constitutional validity of Section 6A to a constitution bench due to the complexities and importance of the matter. On 10 January 2023, a constitution bench of this court broadly identified the primary issue for determination in the present case to be whether Section 6A of the Citizenship Act suffers from any constitutional infirmity. On 17/10/2024, the Constitution Bench, by a majority of 4:1, upheld the validity of Section 6A of the Citizenship Act 1955. Now, going back to the amendment of 2004, which was brought in to the Citizenship Act, the status of migration into the country and their impact is a reality which is something which is being drawing the attention of the political class, the citizenry, and also from a law and order and internal security perspective. When these issues are raising multiple challenges to the citizen, the challenge on account of violation of Article 355 was also raised, interestingly. 355, if I just draw your attention to that, is power of the central government in the scheme of powers, where the central government can actually supersede in emergencies and take over the administration of the states. So Article 355 says, duty of the Union to protect states against external aggression and internal disturbance. It shall be the duty of the Union to protect every state against external aggression and internal disturbance, and to ensure that the government of every state is carried on in accordance with the provisions of this Constitution. This challenge was accepted in the case of Sarbanand Sonowal under Article 355. So the Citizenship Act Section 6A was also questioned for its constitutional validity as an assault on the internal security on account of an external aggression. As we understand, external aggression usually is a military aggression, which is what we think of. But the court in the said case seems to have acknowledged that this is also a factor which needs to be weighed in. This is a factor which has also actually drawn the attention of the court in the present judgment also, as to whether this could be a factor for actually invalidating a legislation as an independent ground of challenge. Normally, we all are familiar, the constitutional virus can be challenged primarily on account of being a written constitution, that it's outside the purview of the legislative competence of the concerned government, or it violates Part 3, or it's manifestly arbitrary. To that is added that by passage of time, as Justice Pardiwal has beautifully put it, temporal unreasonableness. With passage of time, the provision has outlived its original purpose and the object which it sought to achieve. So the classification which may have been good when it was introduced, with passage of time would become redundant, and then it becomes manifestly arbitrary to permit the said provision to continue. And it is in that sense the Section 6A was found to be unconstitutional, because of with passage of time it did not serve its purpose. Now the larger question which has been addressed in addition to Article 355 was an interesting challenge on account of the cultural rights of the citizenry being violated under Article 29. Now when Article 29 has been also made a ground for challenging Section 6A, the challenge was on account of the Assamese culture and their way of life being actually assaulted or being denied on account of the overwhelming immigration of non-Assamese origin people, thereby altering their cultural landscape and depriving them of their cultural rights which are guaranteed to all under Article 29(1). Article 29 linguistic and cultural rights are available to all citizens. So they've invoked this right to say, as a linguistic or a cultural entity, our rights are getting violated on account of this large scale migration which has happened over a period of last 70 years now. If we see, because the legislature has acknowledged migration from the current day Bangladesh, the then East Pakistan from 1950 by enacting a 1950 Act for the purpose of sending people away from Assam, and thereafter again coming back to the multiple attempts being made, including the political agitations within the state of Assam. So this actually brings us to the cusp of the constitutional issues which arise for consideration and how they have been dealt with by the three opinions given by the honorable judges of the Supreme Court in the Constitution bench. 4:1, they uphold the validity. Now, one sense that we can get that all judges were ad idem about the concerns raised in the petitions about the identity and the cultural sanctity of the people of Assam being subjected to a lot of stress as compared to the other border states, which warranted a special provision to be introduced into the Citizenship Act. The political situation and the conflicting priorities, if I may use the word, for the government of India to acknowledge that this is the ancestral land for people of undivided India, and if they choose to come back, the Parliament has acknowledged their right to come back even as late as in 1985 on certain cut-off date which was fixed as to prior to 1/1/1966. So it is a acknowledgement of a legislature of the ancestral land and the people of Indian origin as a concept, as a jurisprudential concept and as a constitutional premise on which a issue could be addressed and considered. In addition to the arguments on violation of Article 14 and 21, 29, as well as our constitutional provisions of Article 355. So these are the broad spectrum of challenges which I would be addressing probably in the next part of this judgment's discourse, because I realize that unless we get the factual backdrop with clarity, the nuances of law, I mean the Article 14 argument or manifest arbitrariness are something we are very familiar with. But the nuance of a temporal unreasonableness would not be appreciated unless we have the factual backdrop in which it had to be invoked, though by a minority opinion of Honorable Justice Pardibala, but it has actually brought out a lot of important issues and flagged the concerns of the citizen of this nation who chose a particular territorial identity with our constitution, recognizing it, the integrity of the territories, being subjected to a lot of deprivation of their rights by passage of time on account of illegal migrants who clearly have been defined to be illegal migrants by the Citizenship Act itself. So that is the endeavor that I will try to do in the next part. Once again, thank you, Seshu sir, for giving me this opportunity and also allowing me to split up into two parts. Thank you, sir.
Thank you, Sridhar. Very nicely explained Constitution Bench judgment on Assam Citizenship Act Section 6. All accords you mentioned, and very nicely page dates wise, various dates, lot of history you have explained. I mean, in fact, we are highly grateful to you. In fact, it's 11th hour catch, believe it or not. Supposed to be an half day. Senior advocate supposed to address had some bereavement in his family, so that then I requested Sridhar. So he always in 11th hour and extremely good. I mean, very highly simplified and it's a very this thing. I mean, now I request Ayush will give vote of thanks. Please, Ayush, please.
Thank you. First of all, thank you, sir, my mentor and senior advocate Sridhar sir, for just simplifying this lecture in the most easiest of backdrop that one can get. Through this course of lecture, I am sure that the academically inclined members present here would love to go and research about this concept of doctrine of temporal unreasonableness, It's great that you highlighted it out at the outset itself, sir. Secondly, sir, I would love to. I would love that the fact that you dwelled into the history, because it's a saying that said that if you want to understand any system, you want to learn how it behaves, you need to delve into the history. So it is this saying that sir has gone into the historical aspects of the case and brought out the various factual facets. Thirdly, sir, I'm also grateful of the fact that you just simplified the key features of Section 6A of the Citizenship Act and made it easily for all the members of the audience hearing right now. And to conclude, sir rightly linked it, the cultural issues of the Assamese people and how the judges were ad idem with regard to the issues faced by them and the conflict existing therein. So, sir has very greatly concluded the issue. And, sir, we are looking forward to the next lecture wherein you will legally dissect this issue. So, I, on behalf of all the members, we are waiting for your next lecture. Secondly, I would like to thank Mr. G.Seshagiri Rao, sir, founder and administrator of the Friday Group, for giving us, all of the people, this opportunity to bring sir on board and have his insights on this topic. Thirdly, I'm grateful to the members of the Friday Group who worked tirelessly behind the back and to make this event happen. Finally, grateful to the senior advocates, other members of the bar herein who have spared their precious time and given their thoughtful silence, which is so rare these days right now. So I'm grateful to all of you members present here. That's it.
Thank you, Ayush, once again. Very nicely explained your vote of thanks and all. Thank you.